Hello, folks, and welcome to our Friday educational program. We will get started right at the top of the hour. Anna may have heard me say this a couple of times already this week, but I do kind of love watching the attendee little panel fill in. I feel like it's just like people walking into a conference room.
It's not amazing, Gina. I'm just amazed that everything turned out really amazing this week.
Yep, this has been a good week. So folks, you're listening to us chat for just a moment. We will start the program in just a few seconds as we let a couple additional attendees make sure they make it into our webinar room this morning. All right, let's go ahead and get started because we only have 60 minutes for a terrific program this morning. I'm Gina Brown with the ABA staff, and I want to welcome you to our Friday educational program, What? My Online Mediation May Not Be Confidential. Before we start, I want to remind you that you can access the program information in the Tech Expo Hub that I will put in the chat window in just a few minutes. Also, if you need Zoom technical information, I will put a link that you can reach out to Zoom directly for help also in that chat window in a few minutes. The presenters welcome questions during the program, and we will set aside a question and answer period before we end. And please put your questions in that Q&A tab within the Zoom toolbar. The program is being recorded, and we will post that recording within the Tech Expo Hub as soon as we have it available, within a few weeks and sooner if we can get it ready. So welcome, and I'm going to turn it over to Anna Sambold to introduce our program and our presenters. Anna?
Thank you, Gina. Good morning or good afternoon, everyone. Welcome to our program. My name is Anna Sambold, and I'm the co-chair of the Tech Expo. It's my big pleasure to introduce you to our speakers today. We have Teresa Frisbee. She's the director of the Dispute Resolution Program at Loyola University of Chicago School of Law. She has mediated and arbitrated hundreds of cases and has taught negotiation, mediation advocacy, and international arbitration to judges, lawyers, physicians, executives, and law students in the US and internationally. Teresa was named the 2018 Mediator of the Year by the Association for Conflict Resolution, Chicago. We have Tyler Codina. He's a second-year law student at Loyola University Chicago School of Law. He's currently pursuing a certificate in transactional law and is interested in a wide range of legal matters affecting businesses. And lastly, we have Jeff Kitchaven. He's ranked in Chambers USA 2020 as one of the country's top mediators, Who Legal 2020. Honor him as a global elite and a top leader in mediation, one of only 5 in the country and 20 in the world. Jeff is an honors graduate of Harvard Law School and Phi Beta Kappa graduate of the University of California at Berkeley. Thank you all for joining us, and looking forward for your program. Please, Taylor, take it away.
Well, thank you, Anna, Gina.
Actually, Jeff, did you want to start?
Yeah, let me just start off, Tyler, and set the stage. And first I want to start by thanking the section of dispute resolution, Anna and Gina, for inviting us to do this presentation. And thank you, Teresa and Tyler, my wonderful writing partners. It was great to team up with you guys and work on this article. So just to set the stage before I introduce Tyler to you, I was contemplating in our Zoom era a mediation in which I would be the only person in California, and the other participants were sprinkled across the country. No 2 people would be in the same state. And so I asked myself, well, by operation of law, what state's privilege or confidentiality law would apply to this mediation? And I asked myself, I was just curious because I don't use a so-called mediation confidentiality agreement. I haven't for about 15 years. And I always tell people when they ask that confidentiality or privilege exists by operation of law. But what law in the Zoom era? So I started poking around into it, and I started reading about conflicts of law and different restatements of the conflicts of law, and very complicated law that I was kind of in over my head. So I thought, well, I better call somebody who perhaps might be more expert in figuring out these kinds of academic matters. And last year, I spoke with Teresa on a panel for the ABA section of dispute resolution at the spring conference in Minnesota. And I thought, well, I'll call my new friend Teresa over at Loyola University of Chicago and see if she'd like to team up with me on this interesting inquiry. And thankfully, she was interested. And we agreed that the best thing to do would be to recruit a bright, hardworking law student to help us with some of the important research. And that's how we happened upon the great Tyler Codina, who just did a bang-up job. And none of this would have been possible without him. So Tyler, why don't we start by allowing you to tell us how this looked from your window into the room and the journey of research that you did that ended up in this article, which ended up ranked #1 on Law 360 in its week of publication as the most read expert analysis article on Law 360. So please.
Perfect. Yeah, so admittedly, when Jeff first presented this problem to me, I was just completely confused. I had no expertise in mediation at all. I think he probably explained it to me 10 times before I even figured out what was going on. And then just from the articles that Jeff had written in the past and some law review articles that Teresa sent me, you know, it just led me on the journey of looking at different cases where, you know, these problems arise. And oftentimes, at least one party is caught by surprise. That stuff they said in their mediation and settlement talks is actually not confidential and will come up to bite them later. So I'm just going to walk us through 3 of the cases that are really the crux of the article. We have Larson v. Larson, Housing versus Housinger, and State of New York versus PricewaterhouseCoopers. So in Larson, which was one of the biggest cases, I think, and one of the more recent ones, especially when we were looking at the article, there were 3 siblings, Arnie and Arla on one side and Charles on the other side. And they were fighting over various family assets, including their father's ranch after he died. And the mediation between them took place in person in Colorado. And there was an express choice of law provision in the mediation settlement agreement that stated that Colorado's law should be applied. So at the end of their mediation, they signed the basic terms of settlement, but then after a couple of versions were passed around, they couldn't really agree on final documentation. So back in Wyoming, Arnie and Arla, the sisters on one side, they moved to enforce the term sheet that was passed around, that they did kind of come to agreement about a little bit. And so they sought the production of a PowerPoint Charles used at the mediation in Colorado. And the PowerPoint detailed matters regarding the ownership of the ranch that he thought would be confidential under Colorado's law. And he was seeking to bar this from discovery. So the magistrate in the district court in Wyoming allowed for the discovery of the PowerPoint under Wyoming law. And this was really, really a true conflict of law, because under Wyoming law, the presentation would have was expressly allowed for discovery, that you know, that was their public policy that they would take. But under Colorado's mediation law, the presentation would have remained confidential, and that's what Charles thought would happen because of the choice of law provision choosing Colorado law. And then on review for abuse of discretion, the 10th Circuit held that Wyoming law governed the dispute actually, despite the choice of law provision in the settlement agreement, which expressly stated that Colorado law should be applied. And in making this decision, the court noted that the choice of law provision normally would have governed and would have allowed the parties to choose which jurisdiction's law was controlling, but Wyoming had an overriding interest which favored the admission of the presentation into evidence. And the exact words they used were that Wyoming courts will refuse to enforce parties' choice of law provisions if the foreign law is contrary to the law, public policy, or the general interests of Wyoming citizens. And then now moving to Hausinger, which was a case that arose in New York between two parties getting a divorce. One of the mediators to the divorce in New York, Carl Vall, he sought to quash a subpoena in the suit for him to testify and produce records that Hausinger's divorce settlement was fair and reasonable at the time that the agreement was made. And in one of the shortest opinions I've ever read, the trial court refused to quash the subpoena, even though the Hausingers had signed a confidentiality agreement. And on appeal, this decision was affirmed as a matter of public policy, and the court rejected the appellant's contention that the court abused its discretion in compelling the discovery of these documents and other communications made in the divorce settlement. Now, in another case in New York, which I'm sure Jeff will expand on later, where they take a very non-restrictive approach to mediation confidentiality, there was a dispute where the New York Attorney General at the time, Eric Schneiderman, sought to compel ExxonMobil and PwC to comply with a subpoena in the state's climate change suit against ExxonMobil. And in response, the two parties contended that the communications between them took place in Texas and were protected from discovery under an accountant-client privilege that existed in that state, similar to a mediation privilege that we would be talking about. But New York doesn't have such a privilege. And also they said that under the second restatement of conflict of laws, Texas privilege law should be chosen to apply to the case. And not surprisingly, especially in New York, the appellate division rejected the interest balancing approach and instead decided to apply New York's law because that's where the trial was taking place. And they do really enjoy using New York law, especially with suits that are brought in that state. So now I'm just gonna pass it off to Jeff, and I think he'll expand on these cases a little bit more and, you know, go into the implications for your practices.
Thank you, Tyler. Teresa, did you want to add anything at this point?
No, go ahead, Jeff. I'll
Okay.
jump in later.
So the fruits of Tyler's research were really pretty stunning, starting with Larson, where you had a mediation that took place in a highly protective state, Colorado. Everybody signed a mediation confidentiality agreement that said Colorado law will apply. And everybody thought that those were the expectations everybody had. And then in the same case, not even in a different case, in the same case, the two siblings go to court in Wyoming and ask the Wyoming court to disregard the local law of where the mediation took place, plus the confidentiality agreement which specified choice of law. And the Wyoming court went along with that, basically on public policy grounds, in a case that had no public policy implications whatsoever, as far as I can tell, right? It was purely private dispute between family members over some trust and estate disputes. So from that case alone, the question is, can we really guarantee confidentiality to anybody when we know that there are courts in places like Wyoming that will disregard the local law of where the mediation took place and confidentiality contracts that people sign? So that alone bursts the bubble. As a practical matter, though, you may think to yourself, well, Wyoming is a beautiful place, but it's a sparsely populated place. It's a a great place with many beautiful natural resources, but it's not really a commercial hub like some other places. And you may ask yourself, what's the chance that my mediation, wherever I am conducting it, is going to become relevant to a later judicial proceeding in Wyoming? Well, okay, maybe that's not so much of a practical problem. But then when we unearthed these cases in New York, which is a major commercial center, and where, if you're doing commercial cases at least, what happens in your mediation anywhere might become relevant to a later lawsuit in New York, well, that's when things got very interesting. Because we see that in the Hausinger case, and Tyler is right, these New York State opinions, they're one paragraph long. They're very terse. They don't go through a lot of legal analysis. They basically just state the conclusions. The Hausinger case actually had two opinions, one by the appellate district, the appellate division, which is the intermediate appellate court, and one by the New York Court of Appeals. And in the New York, in the appellate division case in 2007, the appellate division expressly said that the trial court did not abuse its discretion in disregarding the confidentiality agreement that people signed. Now, when the Court of Appeal got around to looking at it in 2008, the Court of Appeal said, yeah, it's okay to allow this mediator to testify, but it's because there had been a waiver of the mediation confidentiality agreement by the husband in this later judicial proceeding to test the fairness of the marital settlement agreement. But what's really important about the New York Court of Appeals decision in the Hausinger case is it did not disapprove of what the appellate division had said in finding that it's not an abuse of discretion to disregard a mediation confidentiality agreement. So the question is, what good is the mediation confidentiality agreement in New York if it's not an abuse of discretion for a court to disregard it? And then you pile on top of that the state of New York versus PricewaterhouseCoopers case, where the court said, well, we know that where the mediation took place, there was an accountant-client privilege, but we choose to disregard that, and we're going to apply in New York State the law of the forum, the law where the evidence is to be produced. And in New York, to get a little wonky about it for a second, there are two restatements of conflicts of law. The first one is from 1934, and the second one is from 1971. And on issues of this type, the first restatement from 1934 takes what's called the territoriality approach. That is, a court will apply the privilege law of the place where the judicial proceeding is pending or where the evidence is sought to be used. So under the first restatement approach, let's say you have a mediation in a highly protective state like Colorado or California, and then it's tested in a state that has a far less protective view towards mediation confidentiality, like New York, where there's virtually no statutory protection for mediation confidentiality or privilege. So under the first restatement approach, territoriality, well, you apply the law of the forum. After the first restatement was published, that view came in for tremendous criticism for reasons you can imagine. It encourages forum shopping, and it takes away all predictability as to how your mediation is going to be, the confidentiality of your mediation is going to be treated. It'll be treated completely differently in state A versus state B, depending on the law of the forum. So in 1971, the second restatement of conflicts of law took a very different approach, the most significant relationship approach. So courts are supposed to apply the privilege law of the state with the most significant relationship to the communications. So when everybody's physically present in Colorado, well, it's pretty easy to say that's the state that has the most significant relationship with the communications. So under the second restatement approach, generally speaking, the law, the privilege law of the state where the communications took place will apply. But New York kind of bounces back and forth in how they apply these two restatements. There are a lot of New York cases which do apply the second restatement approach, But there's another line of New York cases like PwC versus State of New York versus PwC, which say, nah, we're going to apply the first restatement approach and apply the law of the forum. And, you know, and if you ever have these issues in New York, you can kind of pick the line of cases that you want to apply. My curious mind keeps doing research on this. So Tyler, Teresa, I did find one other case, a case from 2019 called Ambac Assurance Corporation versus Nomura Credit. It was the kind of lawsuit you find in New York involving securitization of mortgages and very complex financial transactions. And in that case, Nomura sought the discovery of documents generated as part of the Wisconsin Insurance Commissioner's regulation of Ambac. Ambac was in basically a receivership proceeding. And it was those communications by the Wisconsin Insurance Commissioner were privileged under Wisconsin law. And in that case from the appellate division, which is also just about 2 or 3 paragraphs long, the court said, oh, well, in this state, notwithstanding PricewaterhouseCoopers, we're going to allow the law, we're going to apply the privilege of the other state of Wisconsin, but only because it's important to the operations of a government agency, the Office of the Insurance Commissioner of the state of Wisconsin. They distinguished PricewaterhouseCoopers on the grounds that the actions of the New York Attorney General were important to the operations of the government of New York. So as a matter of interstate comity, the New York Appellate Division honored the privilege law of Wisconsin. But if it takes interstate comity and respecting the operation of state government of another state and its investigatory and regulatory operations to get around PricewaterhouseCoopers, that's a very narrow distinction indeed, and one that people cannot really, on which people cannot really rely in the standard commercial case. So let me say as a philosophical matter, it's not necessarily bad for courts to want to obtain all the relevant evidence that's before them. We want to have confidence that judges and juries come up with the right decisions. And that's why we have the basic rule of evidence, that's the law everywhere, that all relevant evidence is admissible. We have the traditional view of privilege, what we often call the Wigmore view of privilege, that privilege and confidentiality statutes should be construed as narrowly as they can be, consistently with their purpose, because every time you exclude relevant evidence, you frustrate the search for truth on the part of the judge or jury that is seeking to find truth when it makes its judgment. And it's also not entirely clear how much privilege or confidentiality we really need to conduct effective mediations. The United States Court of Appeal for the Federal Circuit, in a case called In Re MSTG, which I think it's about 15 years old already, but in that case, one side was urging on the Federal Circuit that it should adopt a federal settlement communication privilege, settlement negotiation privilege, similar to the one that had been adopted in the Sixth Circuit a few years before. The Federal Circuit dismissed the claim that a settlement communication privilege was necessary, almost a back of the hand dismissal of the claim, saying that people have been settling cases for generations upon generations upon generations without any such privilege, and the historical record shows that it's not necessary to have that kind of privilege in order to get cases settled. And indeed, when you look at what's happened across the country, there are serious empirical questions about this sort of thing. If you take a look at our 3 biggest cities, Los Angeles, Chicago, and New York, going from west to east, we see that those 3 states have very different regimes for mediation confidentiality or privilege. In California, we have Evidence Code 1115 et sec, which is sometimes referred to as the absolute confidentiality statute. It's not even a privilege statute, and it's incorrect to call it a privilege statute. It's not in the chapter of our Evidence Code on privilege. It's in the chapter on evidence excluded on grounds of public policy. subsequent remedial acts, for example, is another class of evidence excluded on grounds of public policy. And because this is in the grounds of public policy, not privilege, it's not even subject to the same rules of implied waiver or waiver by conduct. You can't impliedly or perhaps even you can't expressly waive mediation confidentiality, but you can't do it impliedly or by conduct. So it's more protective of confidentiality than a privilege law. And it's probably the most protective statute in the country. In Illinois, where Tyler studies and Teresa's a professor, they have the Uniform Mediation Act, which is a privilege statute and has certain exceptions to it. It's a totally different structure for protecting mediation confidentiality. As I say, it's a privilege statute. New York actually has no special statutory protection for mediation privilege or confidentiality. In the Civil Practice Law and Rules, they have a section that is the analog of Federal Rule of Evidence 408, which provides very minimal protection. All it says in substance is that offers or demands in settlement negotiations cannot later be introduced in evidence to prove the strength or weakness of the claims being negotiated. They can, therefore, be introduced for other collateral reasons, and sometimes they are. And then on top of that in New York, we have that appellate division opinion in Hausinger just hanging out there saying that courts don't even have to respect the private confidentiality agreements into which people might enter to make up for the fact that they have only minimal statutory protection, the analog of Federal Rule 408. So what happened in New York? Well, in 2007, after the appellate division opinion in Hausinger, there was quite a brouhaha in the mediation community, and the Uniform Mediation Act is what they called for, and that was the legislation that was introduced in the New York State Legislature. They didn't call for our more extreme California confidentiality statute. They called for the Uniform Mediation Act, and although that was introduced as legislation in the New York State Legislature, it was not passed. And it's been 12 years since 12 or 13 years since the Hausinger opinions were issued. Now, what happens in New York? Well, people are still mediating in New York. There's a lot of mediation that goes on there, and there's a lot of people who are mediators in New York. So query as a factual matter how much statutory or even contractual confidentiality is really necessary for people to conduct effective mediation. And what does this mean for us as a practical matter? Well, I think it calls into question what we say to people in our so-called mediation confidentiality agreements. Many people put into those agreements the kind of language that you saw in the Larson case in Hausinger, with this universal statement: nothing ever said in this mediation can ever be introduced in evidence, any place, in any court, anywhere in the universe, at any time, for any reason, and it goes on. So when you make that statement in a mediation confidentiality agreement, the problem is that that's a promise that we as mediators do not have the power to keep. We don't have the power to keep someone from testing the confidentiality of our mediation in a later judicial proceeding in Wyoming or New York, or one of the few other states that still do follow the territoriality approach of the first restatement. So what will happen? What will happen if you give it enough time? Someday, somebody is going to disclose something confidential in somebody's mediation, and then the confidentiality of that will be tested in a low confidentiality state like Wyoming or New York or Alabama, I believe, is another state that follows the first restatement, and there are a few others. And some judge somewhere is going to say, well, because we are searching for truth and because we want all relevant evidence before us to guarantee the correctness of our decision, we're ordering that this evidence be produced. I think that there is then potential liability for the mediator if the mediator has made a promise in a confidentiality agreement that this sort of thing would never happen. It's possible that there would be a claim for negligent misrepresentation. There might be a claim for breach of contract. There might be a claim for ordinary negligence. There might be a claim for mediator malpractice. And there might be a claim for legal malpractice as well. Why legal malpractice? Because you as the mediator would have either drafted or at least selected the confidentiality agreement which you had people sign. The ABA task force on the model definition of the practice of law defines selecting, drafting, or completing legal documents that affect the legal rights of other people as law practice. So even if all you've done is selected the mediation confidentiality agreement or use the confidentiality agreement provided to you by an organization in which you work, you may well be found to have engaged in law practice and be liable for legal malpractice as well. Now, do I think this is going to happen tomorrow? No, I don't think this is going to happen tomorrow. But what I compare it to is the history of satellite litigation regarding arbitration. I started practicing law, I graduated law school in 1980. And in the early years of my practice, when you would look at the advance sheets, you would almost never find a case dealing with the law of arbitration. Arbitration was this little arcane area of the law that existed, kind of off in its corner, and we didn't pay much attention to it. But nowadays, when you look at the decisions of important appellate courts around the country, barely a month goes by that you don't find some case, some opinion, some decision dealing with some important aspect of arbitration. My sense is that as mediation becomes more well accepted, we, unfortunately, will become the subject of more satellite litigation as well, just as arbitration has happened to arbitration. And all I can tell you is that I don't want to be the mediator sitting there in a courtroom while some jury deliberates whether I have committed malpractice or not. And my hope is that none of you want to put yourself in that position either. So I think there's a serious question as to whether you want to put those kinds of promises of confidentiality in your mediation confidentiality agreements, because they're simply promises that we do not have the power to keep. There are other problems and issues and concerns with mediation confidentiality agreements as well, which we may or may not have time to discuss here. I hope we've put enough on the table to pique your interest and your thought processes and made you examine more carefully some of the practices in which we engage as mediators. Because my belief is that throughout our careers, we should always be learning, trying to improve and increase our level of skills. And we should also always be striving to operate at higher ethical and moral standards and levels as well. So with that, I thank you. And my friend Teresa, take it away.
Well, thanks, Jeff. Just a few thoughts. And first of all, thank you, Tyler and Jeff, for your excellent work on this. And Jeff, you've really made it fun and engaging throughout, and we appreciate that. And Tyler, I'm proud of as a law student from my law school. So one thought is, this issue of lack of predictability and how courts treat privilege and confidentiality, it is a longstanding problem. There's some law review articles about this going back, but lawyers and mediators, and especially lawyers, aren't really paying attention to the complexity of this. So now that mediation has gone online, this is an excellent opportunity to bring this issue forward for lawyers and mediators to think about. I'd like to talk a little bit about my perspective because I am from a Uniform Mediation Act state, Illinois. And the UMA was proposed originally to help solve this problem of predictability and clarity wherever the mediation takes place. It's important to note that under the UMA, a lot of people don't realize that privilege and confidentiality are really two different concepts. So privilege is, as Jeff has talked about, you're really talking about whether some evidence can come into a later proceeding, a hearing, a trial. And confidentiality is more about are we going to disclose this to people outside of the mediation? And the privilege has a lot of exceptions, signed agreement. Is this already available under some kind of open meetings or open records law? Things like, threats to inflict bodily harm, and does it relate to a crime, and malpractice or misconduct by the mediator or really party, non-party participant, attorney, or does it relate to things like abuse and neglect of a child or someone who's a disabled adult? So these are the kinds of things that are accepted already. So we have a long list of exceptions. But then when you look at confidentiality, this is where it's troubling, because under the Uniform Mediation Act, confidentiality is a separate animal, and it's left up to the parties as a matter of contract. And so we have that being our legal framework, and then we have this expectation of confidentiality that has grown up over decades of mediation practice, where everyone's acting as if this mediation is confidential, and long industry practice of either institutions or mediators getting people to sign confidentiality agreements. So there's a part of me that just doesn't feel good about, if I'm not going to put this in an agreement to mediate and ask the parties to sign it, am I just going to hope the lawyers get it right? What kind of mediator am I if I just don't worry about those issues and things being discussed outside of mediation later, and maybe to the media? So I guess I'm thinking, if the mediators aren't going to put a confidentiality provision in the agreement, we need a way to push the lawyers to do it. Is this something we bring up in the pre-mediation conference? Do we actually push them, somebody commit to draft something? I mean, it's so interesting. Lawyers haven't been paying attention. And when I've used these kinds of documents, this seems to be the only kind of contract that lawyers have no comment on. You just have the client sign it, send it right back. And if we start discussing it, is that going to create more conflict? I don't know. Is this just another exception in our long list of exceptions that we're used to in a UMA state? A lot of mediators are saying, and is otherwise required by law, and maybe this could be part of that or more explicitly spelled out. Does it make a difference if you put something very specific in the settlement agreement you reach at the end of mediation? That, not only are we choosing the law of state X, but also the privilege law of that state. Would that help a court respect it later? So those are just some thoughts. I also want to make a pitch for the concept that confidentiality does matter. So, I mean, certainly a lot of judges and scholars have accepted that confidentiality is a crucial element in mediation. It's hard to have empirical evidence of that. Ellen Deason wrote a really interesting article in 2006 addressing the need for confidentiality, and she explores the value of confidentiality in mediation. I think she means privilege too. And what she did was she used a cross-disciplinary approach and found there were these different kinds of trust. And what was really interesting about what she was doing is she pointed out that a judge or legislature that's weighing disclosure against confidentiality, they're often faced with some concrete situation, which would rule in the side of disclosure, right? Here's the document, if it exists, it will help me in this really important way. But the need for confidentiality is more abstract. So how do we balance this? And that's why she looked at literature and other disciplines, and she found that there's a need for trust in mediation for it to function well, and that trust is built on confidentiality. So I relate this to a professional experience of my own as a mediator. So I mediated a dispute about a construction defect between two men. One was older and more experienced, and the other was young and quite wealthy. And I was at the caucus stage and working really hard to learn what were their real concerns in this dispute. And one of them said, "I just don't want to feel like I've been taken." And that was really interesting to me because I had just heard almost the exact same language in the other room. So I asked this guy, you know, can I share that with the other side? Because I just have a feeling it can make a difference and so maybe help us get the case settled. And so he did agree that I could share that in the other room, and the case quickly settled. And by him doing that, I really feel like it was his sense of this is confidential. I can be a little vulnerable here. I can take a little risk that allowed him to do that. So, you know, I agree. It's hard to find, you know, here's some solid empirical evidence, and this is a hotly contested issue, but it's just been such a part of my practice. Maybe I'm just having a hard time giving it up, but I wanted to raise that. So yeah, let's hear maybe from some other people, maybe some idea about what we can do.
We have a question from Chuck Crampton. So Jeff and Teresa, are the best and only mediation confidentiality protection measures: number one, confidentiality agreements by the parties with the advice of counsel and the mediator, expressly incorporating a statutory and court rule confidentiality protections such as the Uniform Mediation Act and Evidence Rule 408, and number two, stipulated qualified protective court orders in mediation of pending litigation cases or by special proceedings for such orders? Wow, that was a long question. But he's basically asking, what are the best and only mediation confidentiality protection measures? What do you think? Confidentiality agreements and stipulated qualified protected court orders?
Well, I'll just give a one-word answer: no. I think, Chuck, you're just digging yourself into a bigger hole. You could put all that stuff in, and I don't think that would have made a darn bit of difference to the 10th Circuit that decided the Larson case. And I don't think that would have made a darn bit of difference to the New York court that disregarded the accountant-client privilege in the PricewaterhouseCoopers case. I just think you're digging yourself in bigger, because by making more and more elaborate promises, if anything goes wrong, that negligent misrepresentation claim against you is just going to get worse. And we not only made this promise, he made this promise. Just imagine yourself being deposed. How many confidentiality promises did you make, Mr. or Miss Mediator? And why did you think courts anywhere around the world would enforce this promise or that promise? And the cross-examination would be terrible. And also the practical impact that it would have on your mediations. What if people start asking you in the mediation, gee, I see this lengthy exposition in your confidentiality agreement here about this confidentiality rule. What if people start asking about that at the beginning of mediations before people sign it? What are you going to do? You start to, well, there's this case from the 10th Circuit that causes an exception, and New York cases do this way, and there's these two restatements. Are you going to start explaining this to people at the beginning of mediations? Because it's not a simple, it's not a two-sentence explanation. So what I think is that what we're really talking about is who decides how candid people should be when they come to mediation. And I think that the answer, who decides how candid people should be, are the parties themselves in consultation with their lawyers. That it's up to their lawyers to advise them how candid to be, how forthcoming to be, and what the risks are that something that they say might come back to haunt them. Teresa, the point that you bring up about people, you know, talking from their heart and talking emotionally and with vulnerability raises all kinds of interesting questions. Typically, we think in terms of somebody saying, oh, well, you know, the light was red after all when I went through the intersection, right? That kind of evidentiary admission as being the kind of thing that would never be introduced in evidence against you. But the fact that somebody feels taken, or they have a sense of pride or anger, they seek revenge, all the kinds of emotional things that we see in mediations a lot, those aren't really, they're not really relevant. I mean, they're not really evidence in the same sense as, oh yes, the light was red after all. So query, if somebody says in a mediation, well, yes, I really am angry, or I feel taken advantage of, I feel disrespected, could that be used in evidence later to impeach somebody's credibility? I mean, maybe, but I wonder, as an empirical matter, does a confidentiality promise have as much to do with things like people talking about their emotions, which are not particularly relevant evidence, I don't think, in the first place?
One thing that occurs to me, it makes me think about priming, right? If you show people a list of words with things like gray and wrinkled, they will actually walk down the hallway more slowly after they've seen the list of words. So, I mean, we're creating this environment. I think part of the sense of that this is confidential does allow these things to happen. And so I hear what you're saying about, is that the kind of thing that's really going to be, coming from somebody's mouth on the stand? That might be different, but I do think we need to tread carefully here, because there is a trend for lawyers to treat mediation just as, a judicial settlement conference. Everybody's holding their cards really close to the vest. You're not having a good exchange of information. You're not getting any really creative options generated. So I don't know exactly how to fix that, but that's just a thought that we're priming people for how they're going to communicate.
So, but as a practitioner myself, this is really hard to, and I don't know how we can handle our mediations, because I understand that the key policies underlying the mediation confidentiality statutes in California and under the Uniform Mediation Act is to promote the peaceful resolution of conflict and disputes through mediation, right? And to promote candor and just tell people that you're gonna be okay, you're gonna be in a safe place where you can speak, and when you can anything that you say can be used against you. And under those promises, the people try to work around their conflict, and there's some magic involved in how mediated disputes resolve, and the resolution can only happen when the participants feel free to speak out their mind and say and offer proposals to see how they can resolve their disputes. So I'm really concerned, and if we don't keep at least those promises, the people will feel free to speak out their mind, and they will be afraid to make any offers to try to resolve their disputes in mediation, and that will discourage mediation in general, and that's my biggest concern.
So Anna, there's a question of whether that is empirically true or whether it's an urban legend. And I think it's an urban legend. And here's what I would point to. Number one, the experience in New York, where they have neither statutory confidentiality, they have only the minimal protections of their analog of Federal Rule 408, and they have no real assurance of contractual protection either, because of what the appellate division did in the Hausinger case. And yet in New York, they have a lot of mediations. There are a lot of professional mediators there. People settle cases. There are robust mediation court annexed programs in federal courts there, and I believe some state courts as well, although I'm not as familiar with the state court programs they have in New York. They're moving towards more court annexed mediation in the state of New York, I understand. So if that were true, then you would think that mediation would completely shrivel in New York, and maybe be okay in Illinois, where they have the UMA, which is a privilege with, as Teresa mentioned, many exceptions, statutory exceptions to the privilege. And the mediation would be most robust in California, but yet there's a lot of mediation going on in Chicago. There's a lot of mediation going on in New York. The other thing to which I would point is the record of the proceedings before the California Law Revision Commission. Lasted several years, 2015, 16, when they were considering whether to recommend to the legislature an exception to the California mediation confidentiality statute when cases involved allegations of malpractice, legal malpractice that took place in mediation. This inquiry from the legislature was in response to the Cassell case, and the exception to the confidentiality for cases of legal malpractice that occur in mediation would be analogous to the exception to the privilege that the UMA has for similar circumstances. And those proceedings took place before the Law Revision Commission. You attended several of them. I attended a lot of them. And speaking on behalf of, as an advocate for that exception to be put into California law, I said through the commission to the California mediation establishment, you keep saying that this absolute confidentiality is necessary to effective mediation. Well, where's the evidence of that? And this dragged on for at least, it was 2 or 3 years.
It was 5 years.
And well, time flies when you're having fun.
I know, right?
The California mediation establishment had plenty of time. There were a lot of people. They're very bright people. They're very committed. They're very sincere. They're very hardworking and devoted to their cause. How much actual evidence did they produce that confidentiality is necessary to effective mediation? And the answer, zero. Zero evidence over a 5-year proceeding before the California Law Revision Commission.
But the interesting part,
somehow, Anna, somehow it has been drummed into mediators that confidentiality, or in California's case, absolute confidentiality, although even that's not really a correct statement, is necessary to effective mediation. Go figure.
but the interesting part was that, the California Law Revision Commission tried to modify the California mediation confidentiality statutes and create a new exception. And for the records, Jeff was the biggest advocate for creating an exception, and I was on the other side. I didn't want to mess up. I didn't want to fix what wasn't broken. So we had a 5 years debate about changing those statutes. And after 5 years, the amazing part is they ended up leaving the statutes in the way they was, because it was a big support for keeping the mediation confidentiality statutes in the way they are. Everybody is kind of the general idea is that mediation needed to be promoted and needed to be encouraged because it's good for society to try to resolve their disputes to mediation, and mediation confidentiality is a big component. And so at the end of 5 years, discussion and debate and so many meetings, right? And that Jeff and I, we attended in Sacramento at the state capitol and in Los Angeles. We ended up, the California Law Revision Commission, they ended up recommending.
That's not true, Anna. The Law Revision Commission voted 4-1 to recommend to the legislature that they adopt the exception, and then the legislation stalled out and was not considered or adopted by the legislature. But the law revision, by a vote of 4-1, did make that recommendation to the legislature.
But what I was about to say is that it didn't become a law. So, but the legislature took another approach, and we ended up with a totally different way to handle the situation. raised by the California Law Revision Commission study. So we ended up with a new bill that that handles everything between client and the lawyer. But they figured that was a better approach, and that's probably why that becomes law in California, because everybody realized that, yeah, we need to promote and we need to protect, and the best way to promote and protect mediation confidentiality and protect the process is by reassuring parties and reassuring people that they will be safe in this process, and they can feel free to speak, and mediation will resolve disputes and is in a peaceful way, and that's good for society. So that's what it makes me sad to hear this, because I am afraid that we had to figure out another way. And I understand the concept of what the issue that you guys are raising, but we have to figure out a way to avoid that, especially in an online mediation setting. So is anything else that you guys recommend? I hear Teresa recommending, well, leave it up to the lawyers, or try to suggest that in the pre-mediation. Is anything else that you guys suggest to try to address this issue? Because I'm really afraid that is gonna, I don't know, it's gonna make the people feel like, really? So whatever I say to you is not confidential? That is, I
want to answer one of the questions, if I can, that I'm seeing in the Q&A, just quickly because of what we were just talking about. And then before we get to that, it says, in light of your comments, what would you say is empirically true with regard to achieving successful mediation? I just want to refer you to the ABA task force on mediation research. That's not probably the correct name, but I was on it a couple of years ago, and there is a report and you can look at it. And there are a lot of variables in mediation, and so it is hard to study empirically. So there were no firm conclusions, but there were some things that looked like they had promise as best practices, like a pre-mediation meeting with the parties where the only goal is to build trust and rapport. But I wanted to get that in before we end, so you can take a look at that report.
Yes, and it's also, what do we really mean by mediation? What makes a family divorce mediation effective, where parties are largely unrepresented by counsel? You're dealing with issues of people's families and children, may be very different than what's required for effective mediation in a construction defect case, or an insurance coverage case, or some, there are many different kinds of matters that we mediate, and one size fits all is probably not the order of the day. You have to adapt to the kind of dispute with which you're dealing, and even the particular people with whom you're dealing, and even the particular mood that in which those people are in a particular day. I think it's a kind of a sad statement, though, with respect to assuring people of confidentiality. I think it's a sad statement about mediation if it were the case that the effectiveness of our process depended on us telling people things about our process which are simply false. Is that the kind of profession we want to have? Where our effectiveness is dependent on our misleading people?
Well, did you recommend something else we can do instead of having a mediation confidentiality agreement?
I mean, what if you had a long list of, here's all the ways that this might end up not being confidential? In fact, there's a good chance of court.
I think that's all up to the lawyers. Again, the question of, Mr. and Miss Client, how candid should, if a client says to a lawyer, how candid should I be in this mediation? That's a question for the lawyer, not the mediator, to answer. It's like asking, how aggressive should I be in the negotiation? What should my opening number be? Well, the lawyers are really the people in the best position to advise the client as to all of these matters. We are not there to be lawyers. Mediation is not the practice of law. And we want mediation as a field, as a profession, to be open to people who are not lawyers. My friend Lee J. Berman is one outstanding example. Cliff Hendler in Canada. There are many others, too many to name. But they're terrific, and we want mediation to be open to those folks. And in order to do that, we have to make sure that mediation is not the practice of law. That means we don't give legal advice to people about such things as how candid they ought to be in mediation. That's up to their lawyers.
Well, I would say that we're not giving advice, but we are basically restating what is in the statutes. For example, in California's case, we're just restating what is in the California Evidence Code. That all the communications, just restating that all communications and all the negotiations occurred during mediation will be confidential and are inadmissible in later civil proceedings.
Well, then some New York court will say, they'll say, we don't care, we're ordering it produced. And then some California mediator, assuming that what's been ordered to be produced is sufficiently sensitive, some California mediator is going to be south of the V in a malpractice lawsuit. And all I can tell you is it's not going to be me. And I hope that for all of those listening on this webinar, I hope for your sakes, it's not you either.
This is Gina Brown with the ABA staff again, and I'm going to jump in there with that note of caution for everyone and say we are done with our 60 minutes, and I want to thank our panelists for being part of this discussion. We'll quickly highlight that I've plugged in an evaluation link, which I encourage you all to fill out, as well as a direct link to the next program that's starting right now, which is sponsored by AAA ICDR. So please click on that and go over there. And again, thank you all for being part of this program today.